liabilities, as you pointed out, were all self-created, so.
I need him to repeat what he just said.
I said there was obviously a farm stand there before this addition was put on.
Okay.
What I said.
Okay. The addition was, that addition was put on in 2006.
Yeah.
Yeah. 2006. This is 2015.
So it was done, the addition was done without permits, it was done illegally, it was done without an inspection.
That's not,
That is absolutely true.
that is not true.
Okay, well, we're going to have to disagree on that.
No, well, we disagree on a lot of things. What's true is, the Hurricane Irene, we came and we got a building permit, and we got, which I have in the car, and I paid the application fee to refurbish the building at the structure that it is right now, and it's the same size it was in 2006. That building is no bigger now than it was in 2006, and we can prove it.
Well, we have a decision from the court that says the opposite. So, I mean, I don't think we should get involved in that debate. So, we got a point where there's either some consensus or a decision on this.
I've said before, Paul's been very generous with charities, with other aspects of this community besides the vegetable stand. But, you know, Al, you built this in total violation of the zoning laws. If we approve your request, we're basically rewarding bad behavior. I don't think that's a good idea. So I'm looking for balance here. And I thought asking you to create a setback was a fair balance. Do you disagree with that?
Well,
I think the concern
variances would establish the balance at this point.
And I think the court's wrong. The court's wrong.
Well, I mean, either the variances, either we make it, we all go to comply with what we feel is correct, or the whole place gets dismantled anyway. We've got the choice.
You talking about the court case? Or you talking about something else? I don't think that the decision that we would make has no bearing on the existing court case.
Well, I mean, in the sense that the existing court case requires it to be teared down, the offending portion to be teared down. The purpose of this whole exercise, as we've gone through now the third or fourth time, is to try and get them into compliance. The only way they can be brought into compliance is by granting the variance, or then reducing the offending size, reducing the offending size to bring it down to what the current code requires. So it's either one or the other. So,
if I may, just to add to that, that there are really three options. If the variances are granted as they are requested, the building can stand and the farm stand can operate. If no variances are granted, the whole structure is going to have to be torn down. If the variances are granted but with a 10-foot setback, from an engineering perspective, it appears as though the structure is still going to have to be torn down. And then the question is are there enough funds available for Mr. Higley to rebuild it with that 10-foot setback? And is it a profitable move to undo all the repairs that were done after Hurricane Irene, rebuild a smaller structure, which is even more expensive than simply tearing it down? I understand that there would be some business there, but this is not an insignificant, it's not a matter of taking a Sawzall and removing 10 feet of roof and putting a couple of support posts in. It's a lot more involved than that. So effectively, there would have to be, if not a complete tear down, it sounds like something close to it if there's a 10-foot variance. And that's why, again, our request is that so that Mr. Higley doesn't have to do that, and so that there can be a business there, that the variances are granted the way that they're written, or the way they're proposed, rather.
I think Mr. Higley should have consulted his own laws before he built this structure.
we understand that. We are where we are today. I mean, this has certainly not been without cost and hardship on the, you know, if what the board is looking to do is a slap on the wrist, I think the last couple of years of litigation have more than provided that for the Higgins.
Also, I just want to say, in follow-up to that, we have a pending decision we're awaiting from the court on the issue of penalties and fines for the zoning infraction. So under Town of Shandaken code, that's part of the remedy that the town's entitled to. So since we don't have that decision yet, any variance that you would be willing to grant, I would condition on the payment of whatever the court determines that to be. We don't know what that is. We don't know what that'll be, but there will be a decision forthcoming on that and a determination, and and that will answer part of your concern about, which is a valid concern about, someone, the deterrent for doing this in violation of the law. Okay, so I just wanted to clarify that.
And if I could just briefly add to that, I'm sorry to go back to it, but I think the amount of the fines that the town is seeking, and again, as Mr. Walensky mentioned, that issue is before the judge, especially for a farm stand. That is not a slap on the wrist. That is far more. So if the board is considering whether some punishment is sought or needed or deserved because of the structure, that's what the court case is about. That's not what we're here for today. I'm not seeking to take the bat out of your hands, but the bat is in the judge's hands. And so I would ask the board to trust that process will provide whatever remedy the town is seeking. And here, hopefully, we can constructively move forward so there can be a farm stand as part of this community. And by the way, that includes jobs for the community as well.
Understood. I don't think our role here is to punish anyone. Our role here is to make sure the zoning laws are adequately vetted and enforced and followed. Correct?
I think that's right, and I think that if the concern is precedent that is set, well, again, there's an enforcement mechanism, and the town has used that enforcement mechanism. And if the town is looking for deterrent value, it has plenty to point to anybody else, whether it's a Crossroads development or anyone else, to say this is what happens if the zoning laws aren't followed. The town has made that clear. I think you've got plenty to point to there.
Well, whatever that section, it's an overlaying section.
You mean the 3.5 foot
3.5
approach?
feet, that's at least get that over.
I think there's Mr. Brewer represented, there's a note on the map that requires that already.
Yeah.
This would be taken back from.
I'm still looking.
What's that?
No.
No.
It doesn't. Because it's a new application.
New application.
So, you want to make a motion?
You need a, you need
I'm not.
Make a motion to accept the four variances as they were filed. This would be, we're having come to a vote with you preparing the final statement to be voted on next month at the meeting.
Okay, with the condition on the payment of the fines?
Yes. Put it to a vote.
I'll second you.
Okay.
So we didn't need to put language in there about the overhang over the
I see.
Well, that's,
It's on the map, but I can add language about that.
I mean, it says a map.
Yeah, that's on the.
Yeah, well, we could refer to the map in the decision, and we can
Just
also.
say as per latest provision of drawing.
And we can also express it in words as well.
Yeah. And the DOT will be complied with.
It's also got to be subject to planning board site plan approval.
So we're not voting on the resolution, we are.
No, it's not, there's nothing drafted yet, but you can take a vote and direct me to draft a resolution for your review. And you can ratify it at your next meeting. Or you could just send me away, have a consensus here right now, not take a vote, have a consensus here right now, ask me to draft a decision that reflects that consensus, and we can review it next month and formally act on it.
If I may make a request.
We have, from the close of the public hearing, we have 62 days to make a decision. There is a motion on it.
Yeah. Second. Roll call vote.
No, is there any further discussion on it?
Can we reread the motion first? Can we hear the motion again?
Keith made a motion to accept the 4 variances as is with the final statement on the condition they pay what the court demands them to pay. As you guys said.
Right. And then,
Joe seconded it.
there were two other conditions.
Just like
One that the
Oh, the planning board site plan approval?
And that the overhang be removed.
Right.
So that no part of the structure can encroach beyond the property line.
yeah, just, you can.
I would do it that way.
Yeah, you
No
can
part
further
of the
define it
structure.
by saying as per latest revision 920, whatever it is. Yeah, 9/21/2015.
Okay, you guys comfortable with that?
I am.
Yes.
Okay, roll call vote?
Okay, Board Member Johnson,
Yes.
Board Member Reese,
No.
Board Member Lodi,
No.
Board Member Michaels,
Yes.
Board Member Blumetti.
Yes.
Don't steal your pen.
Just, I think we ought to reflect for the record that this was sent to, because this was a new application, it got resent to the county for review. It was sent on the 8th of October. It's now more than 30 days, and we've received nothing back from the county. So pursuant to the general municipal law, we were able to take that action. Okay. Otherwise, if the time hadn't been up, we wouldn't have been able to take the action.
That's why I asked you at the beginning, if you put any correspondence from the county.
Yeah.
Make sure that.
But, so the enforcement of this is still pursuant to the decision of the county planning board, or is it rather zoning board?
No.
No, the county has a
Window closed.
Windows closed.
Okay.
I don't know why the county's, if you recall, the county's main concern in the last go-around was the parking and the circulation issue, the DOT issue.
All right, we still have some other business we have to do.
Thank you, Larry.
Thank you. So I'm going to draft the decision for you guys. Four-wheel drive.
That's a tough act to follow.
Anything more exciting?
We're with you too.
How are you? My name's Jeff.
Hey, Jeff. Mark Lodi.
Joe Michaels. Gary? So Trev?
Hey, sir.
Another familiar face.
Yeah.
Good evening. So we've got a much more, I think, pedestrian map here. This is an area variance that had to do with the setback requirements for Jeff and Brooks' property. 108 Route 214. It's in the HR district. The property had previously been used for longer-term rentals. The use is being changed to shorter-term rentals, and as a result of that change in use, the pre-existing status, non-conforming status of the property required that we come back before you, because even though this was used previously for transits, we fall under a different category now, given the short-term use that's being proposed. Mr. Brewer's map shows that the 3 units that are being involved are variously, I think, 25 feet to 53 feet from the property line. Significantly, the property line is the property line, but there really are no structures right there.
You mean on adjacent properties?
Yes,
Or the other?
yeah, the adjacent property. Mr. Walensky was kind enough to read off the various statutory requirements for variances. And as he stated, essentially what the ZBA is asked to do when an area variance is being submitted is to weigh the benefit to the applicant against the detriment to the neighborhood. I've been to the property, I've looked at it. Given the fact that this property was used before as a rental property, the impact here is not significantly different than the impact before. And in fact, if you think about it from a traffic perspective, if you have people living there all the time in those 3 units, sometimes there's 1 car, sometimes there's 2 per family. Here you've got people who are largely coming in by bus and not increasing the traffic impact in any way whatever. If they do come, they're going to come in 1 car. They're not going to come in 2 cars and live there for an extended period. So, given the prior use and given the negligible impact on the surrounding area, keep in mind also, even though we're in an HR district and the neighbors have a commercial district, there's a 17 unit in, just very, very close by. So I don't see there being a negative impact on the community. I think that in fact the impact is probably going to be lesser given the nature of the use. And I don't see, if you look at it objectively, I don't see that there's any significant environmental negative impact. There's really not any significant difference over the historical use of the property over all those years when it was owned by the prior owner.
This is being used now as a long-term rental?
These are being used now. It's proposed that they're being used as short-term rentals.
No, but now,
But it is right now. What
They previously listed long-term rentals.
The building as it sets now is being used as long, people are living there.
We live there.
So, yeah, but I mean, as far as the rental, I mean, there's
You mean previously or now?
now.
Now, no, we're talking about short-term rentals now. If they were long-term rentals, we wouldn't be before you.
But there are currently short-term.
No, we had before when I started doing the short-term rentals, I wasn't aware that there was a difference in the town code. When the town alerted me that there was a difference, I began this process with the planning board wanted to propose that I may use this in a short-term rental property.
And can you show me which specific structures
This, where the dotted line is right here, it's stacked up too.
This the main house?
This is my home.
Okay, yeah.
This is, right on this, there's a one bedroom here and two bedroom right stacked on top of each other.
Okay.
And then this, I propose to be it's a cottage, a two bedroom cottage.
Okay, so you're gonna keep your apartment or whatever in the main house as your primary residence?
Yes, the majority of the structure.
And then you've got the two smaller rentals in the main house.
Yep,
And then you
and-
have the cottage as a separate entity.
Correct.
So you have three rental units.
Yes.
One other question, she's gonna sound a name, but what is that casket shape?
Yeah, those are the same thing.
That's where I bury people. It's
The neighbor.
it's just an island of Pachysandra.
It's a planter.
Yeah, well, the damn thing's got the shape of a casket.
It's weird. That's Don Brewer's fault.
Michael, Mike, like 100 years ago, I think that was a cesspool because we worked there one time and back in there, we found it with a truck.
What was it, an old school bus?
No, it was a laid up pit, but it didn't stand the weight very well.
You found it with the truck fell in.
In fact, yeah, it went through it. So that's probably why it's still.
That's why the Pachysandra does so well, all that fertilizer.
Yeah,
Okay.
good stuff, but
So,
but
Jeff-
you're not proposing any changes of the outside of the building?
Absolutely not.
So you're going for a change of usage?
Yeah.
Yes, this is treated under a different category than the long-term rental was.
One, just for clarification, I see that the variance request has to do with 11645.
Yes.
Which I-
Vacation colonies, cabin and cottage rentals.
Right.
Which is the closest thing that we can define as short-term versus long-term rentals.
Oh, that's the distinction, because I don't
That's what the-
perceive this as being a bungalow colony or a cottage.
As it stands
Colony.
in the zoning code, what he proposes, we do not have a definitive setup for it. So we had to
Come under
pick,
B&B, would it come under?
No.
there's no food
Because I'm
involved.
not serving any food.
Well, where in our code book does it address short-term rentals versus long-term rentals? That's what it-
It's actually, if you read it, I don't know if you, are you on the page?
I'm on 11640.
Okay, read under E, vacation colonies available for rent to transients. It's right at section, the initial,
This is not a residential community?
We're not there, we're not there yet.
You're not there yet?
you're on page 11682.
Yep.
Section
Ma'am, please, our public hearing is coming.
So it's vacation colonies, including cabin and cottage developments, available for rent to transients in the residential districts and the non-residential districts. Provided that, and you come up with the 5 requirements. First 4 they met. It's the 5th one due to the location to the property lines.
Well, it is important that you understand that this is a permitted use with a special use permit.
Right.
So you need a use variance.
No, we did not, no.
No, it's a
No.
permitted use special permit. We tried to fit this into believe me, we spent hours trying to fit this into a classification where we wouldn't have to. And this was the closest we could come up with that was permitted, that we didn't have to go beyond.
This isn't, so going before the planning board for a special use permit was not,
We did.
you
We
did
did.
twice.
And
they
it
did-
appears as though they're ready to approve us, subject to the determination of the ZBA on this
Doesn't fit
application.
under the categories of pre-existing non-conforming?
That's what I thought it should, but it was determined by the planning board that since there is a different categorization, that
Short-term versus
that we
long-term
lost
was the
that we
distinction.
lost the pre-existing use status in their opinion.
Well, like that, Jeff, you used to rent these apartments out long-term, correct?
Well,
You had tenants,
Yeah, when we purchased the place, we had tenants. When they moved out, we intended to,
Pre-existing non-conforming.
Go to short-term.
we decided to go to short-term.
So what was the reasoning behind that strategy?
What was the reasoning behind that strategy?
It isn't changing the use.
I
use of those spaces.
prefer to be in hospitality than in the landlording world. It's a little bit easier on our soul as a family.
Day or a week.
I would have thought the long-term stability,
I think we're
long-term tenant minded to leave. It
Well,
was
in
financial minded.
in
Have
this
have you been a landlord
It's
for
not changing.
long?
No.
My experience,
Let me tell you.
I don't know if it's really relevant, but my experience with the tenants that were there was extremely negative. One had not paid rent in 6 months. One had to be dragged out by the cops after crashing his car into the cop car. And the other one was a perfectly fine guy, except for 2 weeks out of the month. He would disappear for 2 weeks and come back ruined. So I felt that this was bringing something better to the community as far as like a warm
Excuse
hostility.
me, as a member of the public, there's 2 conversations going on. I'm trying to keep up, but with this conversation and that one going on, can you try to limit it to one so we can understand what's going on?
Which one would you like to take?
Well, I'd like to hear it all, but one at a time.
the floor.
Just turn up your hearing aid.
I can't, I left my home.
We thought, as a family with experience running hospitality businesses and restaurants and a coffee shop that I owned, we thought that it was in our wheelhouse more to have sort of a short-term hospitality situation. It's I don't know. It's just when we bought. First of all, when we bought this place, it said, "Imagine your own bed and breakfast." So, like the first thing that we did is we imagined our own bed and breakfast, but we had long-term tenants in there that I did not. It will come up tonight that I evicted them, which will be the furthest thing from the truth. When they decided to move, we began to do this. I put no pressure on anybody who was paying rent on time to move out. My personal experiences with them notwithstanding, I was a professional landlord in that matter.
Okay. I don't think that's actually.
That has no bearing on.
Well,
Okay.
you're gonna hear stuff,
That's
and you're also gonna hear what a residential neighborhood it is, and people don't seem to understand what a permitted use means.
Okay. Because this brings up the whole issue of the Airbnb phenomenon.
This is not an Airbnb.
This is not an Airbnb.
This is not an Airbnb situation. That's the other thing you're going to hear that's also inaccurate. This is not an Airbnb. There is no food being served. Airbnb is the way you market it. It's the way you go on the internet. Okay, this is a use question. This is not an Airbnb question. It's a use question. And all that's happening here is we're changing long-term use to short-term use. And if you're going to apply the statutory standards, you're going to look at what is the impact on the neighborhood. Is there a significant adverse impact on the neighborhood? Does that significant adverse impact on the neighborhood outweigh the desire of a family to go into a particular line of work that is permitted by the zoning law? That's really the balancing determination that you have to make.
Okay.
Well, I still don't understand why
I don't either, Keith. I don't either, Keith, but that's the way the planning board came
I
down.
think because the statute reads that an accessory cottage or occupied space needs to be 100 feet from the nearest property line.
Except that the prior use was there and they weren't 100
Right,
feet
but why is
from
it
the
not, the
property
question is, why is it not pre-existing non-conforming?
Yeah,
Because this obviously has a long history.
Yeah, it's pre-zoning to start with. It's a lot of.
There's also a salon.
Yes, I know, I knew those
Pauline's
Schlossers.
Salon forever.
Yeah.
Can we get a
Yeah,
different
well,
thing?
so we reserved our rights with the planning board, but we thought it was, let's go before you guys and see what you
I
have
mean,
to say.
this is not the public hearing. Now, I'm not the chairman.
Okay, but I think you need to see this.
Okay.
Okay, but it's now the